Welcome to Term Talk, the video podcast from the Federal Judicial Center that covers the Supreme Court decisions from each term likely to have the most impact for the lower courts. I'm Beth Wiggins, the Director of the Research Division. We're going to discuss Murthy versus Missouri and National Rifle Association of America versus Vullo. Both decisions address when government speech infringes on the speech of others in violation of the First Amendment. In another episode, we'll discuss the First Amendment issues related to the use of social media by government officials and state attempts to limit content moderation by social media companies. Joining me today are Erwin Chemerinsky, Dean and Jesse H. Choper, Distinguished Professor of Law at the University of California, Berkeley School of Law, and Michael McConnell, former judge on the 10th Circuit Court of Appeals, and now Richard and Frances Mallery, Professor of Law and Director of the Constitutional Law Center at Stanford University Law School, and Senior Fellow at the Hoover Institution. Thank you both for being here.
Thank you.
Thanks for inviting me.
So one of the themes that's emerged this term, though not resolved, is when government speech results in the infringement of another's free speech rights. Murthy versus Missouri was dismissed by the court for lack of standing, but it gives us parameters for how court officials should interact with private parties, in this case, social media companies, with the purpose of shaping their message. Erwin, can you take us through the background of this case and its holding?
Social media companies engage in content moderation all the time. They became particularly concerned about false speech related to the COVID vaccine and also the 2020 election. They did many things. They took down some of the false speech. They deplatformed some of the speakers. They engaged in fact-checking and labeling. And officials of the Biden administration encouraged the social media platforms to take this action against the false speech. Lawsuit was brought against the Biden administration. There were 2 states, Missouri and Louisiana, who sued, and 5 users of social media. A district court issued a very broad injunction against the Biden administration, saying what it had done had violated the First Amendment. The United States Court of Appeals for the Fifth Circuit largely affirmed. It dismissed some of the agencies, but kept in place a broad injunction against the White House, the FBI, the Center for Disease Control, and other agencies. The Fifth Circuit said that as to individuals, the government pressure was coercion that suppressed speech. And as to the states, the Fifth Circuit said that what the Biden administration did was coercion and encouragement that suppressed state official speech. The Fifth Circuit affirmed an injunction that said that the Biden administration could not, quote, coerce or significantly encourage social media platforms to engage in censorship. The Supreme Court overruled the Fifth Circuit and said that the case should be dismissed on standing grounds. Justice Barrett wrote the opinion for the court. She reminded everyone that in order to standing in federal court, there are 3 constitutional requirements. There must be injury, causation, and redressability. Her opinion focused especially on causation, said social media platforms are private entities that make their own choices what content to include or exclude, said it couldn't be shown that anything the Biden administration did caused the choices of social media platforms with regard to taking down speech or deplatforming.
So, Michael, what was the court's reasoning in reaching that decision?
Well, Beth, this is a very complicated case. It was a sprawling case with huge numbers of allegations. By the way, not all about false speech. Some of the things that were taken down have later been proven to be true. Some of them were statements of opinion by distinguished, respected academics on such things as the advisability of the lockdowns. But it was a case that was like the kitchen sink. It had everything in it, and the preliminary injunction in the case was, as Erwin said, quite broad. Applying to large numbers of federal officials, including people in the White House, and giving a requirement that is backed up by a judicial injunction that depends upon a line which is really very difficult to draw. The line between coercion or significant encouragement and persuasion is difficult. Now, there were a number of factual situations that were raised by the plaintiffs. Some of them seem much more troubling than others. And the idea, I think the fundamental problem that the court perceived here is that they were proceeding from essentially a series of anecdotal episodes, some of them bad, some of them not so bad, to a very sweeping injunction. Now, in this case, the court chose to discipline this rather undisciplined piece of legislation through the device of standing. It could have just as easily done it in other ways, but standing was convenient because of the need, as Erwin was explaining, to show injury, causation, and redressability. A very difficult thing to do when the social media companies are already engaging in content moderation. And essentially what the government was urging them to do was to do more of it, to take down more than the companies might have been inclined to do. Had there been a more surgical attack on particular actions of the government, the case might have come out a different way.
Okay. Thank you. Well, so Erwin, Justices Alito, Thomas, and Gorsuch dissented. What did they have to say?
Justice Alito said that this is one of the most important free speech cases to come to the Supreme Court in years. He wanted to apply Banham Books versus Sullivan, a 1963 decision that said that coercion by the government violates the First Amendment, even if it's just government officials engaging in speech. He also wanted to apply a Supreme Court decision from a few weeks earlier that we'll talk about, National Rifle Association versus Vullo, where the court found coercion. And he said that here, there were adequate allegations to support the preliminary injunction to find coercion. And it was a dissent that had a very angry tone.
Okay. So what are the takeaways for the lower courts, Erwin?
I think what's most important is that this is a case about standing. And what Justice Barrett's majority opinion emphasizes is the need to link each injury causally to conduct by the defendant. And I very much agree with what Michael said just a moment ago, that I think what explains this case is social media platforms are always engaging in content moderation. Very hard to link any particular content moderation to the Biden administration speech.
Mm-hmm. So, Michael, what would you add for the lower courts to consider?
So I think the key thing, of course, this is a standing case, and Erwin is right that is crucial. But I think probably the more important thing is that this is a preliminary injunction, a very broad preliminary injunction, and one that would be very difficult for the federal officials to know when they're stepping over the line. I think the court was primarily interested in or concerned about the breadth of the relief in the case, and so it turned to standing as a means of disciplining the litigation.
Well, why don't we move on to the case both of you have already mentioned, National Rifle Association versus Vullo. Michael, let's just continue with you for a minute. Can you explain the facts of that case and take us through how the case ended up at the Supreme Court?
Yeah, so this is a case involving New York insurance regulators and the National Rifle Association. And the National Rifle Association is an advocacy organization that advocates for Second Amendment gun rights. It's very, controversial and partisan, dividing kind of question. But the NRA, like many membership organizations, engages in membership activities. In this case, the providing of particular types of insurance. They contract with insurance companies to provide services to their members. In this case, some of those programs were actually in violation, I think, seemingly technical violation of New York law. And and the New York regulators had been turning a blind eye to this, except that they decided they basically went to the insurance companies and told them that they would, throw the book at them. They'd bring in the regulators and start, fly-specking everything they did unless they cut off the National Rifle Association. And at least at the motion to dismiss stage, where this case was decided, the allegations were quite clear that a reasonable fact finder could find from those allegations that the New York regulators were attempting to coerce the insurance companies, and that their motivation for doing that was because of objections to the advocacy of the NRA. And as a result of that, the courts held that this case could go forward. It's often described as a victory for the NRA, and maybe it will be, but actually what it was a reversal of a motion of a dismissal order allowing the case to proceed.
Okay, so, well, Erwin, this was a unanimous opinion written by Justice Sotomayor. What's its reasoning?
I think Michael put his finger on the key to Justice Sotomayor's opinion. She stressed that this is on a motion to dismiss, so all of the allegations of the complaint have to be taken as true. She focused here on a case I mentioned earlier, Bantam Books versus Sullivan from 1963. That involved the Rhode Island Commission on Morality and Decency identifying books that were objectionable and saying that bookstores that sold them could face criminal prosecution. Police actually went to some of those bookstores and threatened the owners with prosecution. Justice Sotomayor, both the beginning and the conclusion opinion, said that this is governed by Bantam Books versus Sullivan. The court wasn't going any further than that. What the Supreme Court said is that officials can't use the threat of sanctions to achieve the suppression of disfavored speech. She said, in order to state a claim, there's going to have to be conduct that's reasonably understood to convey a threat of adverse action, and it was done in order to punish or suppress speech. Justice Sotomayor here pointed to a number of things. The commission's authority that Vullo was invoking, the commission's communications through Vullo, and the coerced party's reaction to the communications. But I think the key is the court is saying there were sufficient allegations of coercion by Vullo to allow the case to go forward.
Michael, what do the concurrences from Justice Gorsuch and Justice Jackson add to this analysis?
I think Justice Jackson's concurrence is very thoughtful and very important to understanding the case, because her essential point is that coercion in the abstract is not a constitutional claim. You have to ask coercion to do what? And then she further distinguished between two different kinds of First Amendment claim. There's retaliation claims, which is where the government is taking action essentially to punish someone for free speech that they did not like. And then there are censorship claims where what the government is doing is coercing a free speech media intermediary to censor the plaintiff's speech. Murthy would have been a censorship case. According to Justice Jackson, Vullo is really more of a retaliation case, because these insurance companies are not media companies. They don't have anything, they don't have any control over the NRA's speech. What was going on here was trying to use them as a way in order to retaliate, at least according to the allegations, to retaliate against the NRA. And Justice Jackson was essentially complaining very gently that the majority opinion was failing to make that a distinction, and that in other cases down the road that could really make a difference. Justice Gorsuch's point is similar to something a point he makes in a number of different contexts. The lower courts had applied a rather nebulous four-part test to this, and then it sort of divided out the strands of each of that of the analysis, and and really lost sight of the underlying question of whether the officials were coercing a free speech retaliation or not. And Gorsuch's warning that the court should not use these multi-part tests as a way of avoiding the essential question in the case. I do think that this is the first case since important case to get to the Supreme Court, at least since Bantam books in this area. I would predict that there are going to be more cases in the future, and many of them I suspect are going to be closer to the line. One of the reasons this court could be unanimous in Vullo is because the allegations just seem quite outrageous and blatant. But many cases are going to be closer to the mark and are going to be much more difficult for the lower courts to analyze.
Mm-hmm. Erwin, how about you?
I agree with Michael. I think the underlying issue is an enormously important and difficult one. When is speech by government officials by itself without sanctions enough to infringe the speech rights of others? I sent a message to the students every fall, encourage them to speak with one another with civility, treat one another with respect, not to engage in hateful expression. Last year, students said, by saying that, I'm chilling their speech and violating their First Amendment rights. And I think what the Supreme Court did in this case is be very clear that there has to be a threat of sanctions in order for speech by government officials to itself be a violation of the First Amendment.
Okay. Well, thanks, Erwin, and thanks, Michael, both of you, for sharing your expertise with us today, and look forward to talking with you about the other First Amendment cases later.
Thank you.
Thank you.